Something big is brewing in Abuja, and this story has all the ingredients of a political thriller. The Federal High Court in Abuja has fixed February 24, 2026 to begin hearing a suit that could wipe out some political parties before the 2027 general elections even begin. The parties involved are the African Democratic Congress, known as the ADC, the Accord Party, the Zenith Labour Party, and the Action Alliance. If this suit succeeds, these parties could be deregistered and completely shut out of the 2027 race. The suit was filed by the Incorporated Trustees of the National Forum of Former Legislators, a group of former members of the National Assembly. They are asking the court to compel the Independent National Electoral Commission, INEC, to remove these parties from the official register. The case marked FHC/ABJ/CS/2637/25 names both INEC and the Attorney General of the Federation as defendants. This is not a minor legal dispute. It goes straight to the heart of Nigeria's constitutional framework. The plaintiffs are relying on Section 225A of the 1999 Constitution as amended and Section 75(4) of the Electoral Act 2022. In simple terms, these provisions require political parties to demonstrate electoral performance in order to remain registered. That means winning at least 25% of votes in one state during a presidential election, winning a local government area in a governorship election, or securing at least one elective seat at any level, from councillorship to the National Assembly. According to the former lawmakers, these parties have failed to meet those thresholds. They argue that not one ward out of Nigeria's 8,809 wards, not one local government out of 774, and not a single elective seat has been secured by the affected parties. Their position is that INEC has allowed them to remain on the register in breach of constitutional provisions. But there is a deeper political layer to this case. The ADC in particular has recently emerged as a rallying platform for opposition figures ahead of 2027. Former Senate President David Mark is currently serving as its national chairman, and several politicians are reportedly considering it as a vehicle to challenge President Bola Tinubu's re-election bid. That development has fueled speculation. Supporters of the lawsuit insist it is strictly about enforcing the law. Critics, however, believe the timing raises serious political questions. Is this a genuine public interest case aimed at constitutional compliance, or could it be part of a broader political chess move targeting an emerging opposition coalition before it gathers strength? That is a question many Nigerians are now asking. Anyone who has followed Nigerian politics knows that the courtroom has become just as important as the campaign trail. Legal battles often shape political outcomes long before voters cast their ballots. That is why February 24 carries such weight. The outcome will not only affect four parties, it could redefine the rules heading into 2027. If the court rules in favor of the plaintiffs and orders INEC to deregister the parties, it could set a powerful precedent. Other underperforming parties might also face similar challenges. On the other hand, if the court dismisses the suit, it could reaffirm the rights of smaller parties to remain in the political arena regardless of electoral performance. The case was initially scheduled for February 16, but proceedings did not begin because Justice Peter Lifu was unavailable. However, all parties were present and fully represented. The legal teams include senior advocates of Nigeria on each side, signaling that this will be a high-stakes constitutional battle when arguments begin in earnest. At the center of the dispute is a fundamental question. Has INEC failed in its constitutional duty by keeping certain parties on the register despite alleged non-performance? And if those parties continue to hold congresses, conduct primaries, and field candidates in 2027, would that amount to a violation of the law? The plaintiffs argue that allowing inactive or non-performing parties to remain registered contributes to an overcrowded ballot and strains public resources. They believe deregistration would strengthen the electoral system by ensuring that only viable parties remain. Opponents of the suit argue that democracy thrives on political diversity and that smaller parties should not be eliminated simply because they have yet to win seats. They warn that deregistration could shrink political space and limit alternatives for voters. As Nigeria counts down to February 24, attention will be firmly fixed on the Federal High Court in Abuja. The ruling could reshape the political landscape well before campaign season officially begins. Will the court allow these parties to survive and contest in 2027, or will the constitutional hammer fall? The answer may determine not only the fate of a few political parties, but also the broader balance of power heading into one of Nigeria's most anticipated elections.